I'm Steven Vladeck, author and professor at Georgetown University Law Center. I'm here today to answer your questions from the internet. This is Supreme Court Support. At Crypto King asks, why do Supreme Court justices receive life appointments while every other type of judge has retirement ages? So this is actually a real disconnect between the federal courts and state courts. Most states have imposed retirement ages on their judges and justices. The federal courts have not. And so under Article 3 of the federal Constitution, the Supreme Court, the intermediate federal courts of appeals, the 94 federal district courts, all of them serve during what the Constitution calls good behavior. And the idea here was to provide a modicum of protection against being forced off the bench for anything other than the kind of misconduct that might warrant impeachment by the House of Representatives and removal by the Senate. At K-Pola Pratik asks, so how do Supreme Court justices get appointed? The appointments process is actually pretty straightforward. The president gets to nominate anyone, doesn't matter how old they are, where they're from, what their qualifications are, to be a Supreme Court justice, and as long as they're confirmed by a majority of the Senate, they get the job. VAW Navy vet asks, are confirmation hearings effective in preventing unqualified appointments, or have they become mere formalities? This really does vary and has varied historically based upon who the president is and based upon which party controls the Senate. There have been moments in American history where the Senate really has exercised a rigorous oversight role in vetting the Supreme Court's nominees. There have been some who have been blocked by the Senate, some who were withdrawn because they didn't have the votes in the Senate. But I think what we've seen lately is when the presidents of the same party as a majority of the Senate, there really is a push to get through the president's nominees. And so I think we've seen less of that criticism from the Senate in recent nomination processes. Professional Cat 437, could somebody explain what the 2016 drama of Obama being unable to appoint a new Supreme Court justice was? So in February of 2016, Justice Antonin Scalia, who was in many respects the leader of the court's then extant 4 conservative justice wing, unexpectedly passed away while he was on the court, opening up a seat for President Obama to presumably fill. President Obama quickly nominated an incredibly moderate and relatively older candidate, then DC Circuit Judge Merrick Garland, but the Republicans, who at the time had a majority in the Senate, banded together and committed to provide no process, not even to have a vote up or down on Merrick Garland as a nominee, but rather to keep that seat open through the November 2016 presidential election until President Trump was sworn in January, at which point he nominated Neil Gorsuch and the Senate confirmed Gorsuch to fill that seat. So the Constitution does not require the Senate to vote. Really, historically, the expectation has been that if the Senate were going to shirk its duty in such a shameless and transparent way, it would face political consequences for doing so. If anything, in 2016, the opposite happened, where the Senate holding that seat open provided a number of folks who might not otherwise have wanted to with reasons to vote for President Trump. It's also worth keeping in mind that when the Constitution was written, we didn't have political parties. Had the founders known that we were going to have really a deeply entrenched 2-party system, it's not hard to imagine they would have done some things very differently. At Danny Giga asks, the Supreme Court is not apolitical. Has it ever been? We should distinguish here between a court that is political and a court that is partisan. The Supreme Court has always been political in the sense that it's always been involved in institutional conversations with the other branches of government. Some of the court's most important early decisions come as part of a pretty sophisticated inter-branch conversation with President Jefferson, with Congress. It's only since 2010 that we have a Supreme Court where every justice's ideology aligns with the party of the president who appointed them. That's part of why today the court seems so much more divided along partisan lines than was true as recently as 20 years ago. From Reddit, how does the process of a court case going to the Supreme Court work? Just about every case the Supreme Court hears has gone through multiple levels of litigation in lower courts. Those lower courts could be lower federal courts, or they could be state courts. And under both the Constitution and the relevant statutes Congress has passed, once a case has gone through those lower courts, the Supreme Court has the power to hear an appeal if whoever lost in the lower courts wants the court to do so. And if it's coming from a lower state court, as long as there's a federal issue in the case, as long as the case turns on federal law, the Supreme Court has the power to hear it. This is actually a place where the Supreme Court's power and its docket has actually shifted a lot over time. So from 1789, when the Supreme Court was created, until 1891, the Supreme Court actually had to hear every single appeal that Congress told it to. It's only since 1891 that Congress has broadly given the justices the power to pick and choose almost all of the cases they hear. That process is given this Latin term, certiorari, which we abbreviate to cert, because we can't really spell it. And the basic gist is the Supreme Court votes, and it takes 4 of the 9 justices to agree to hear a case for the court to take it up. What that means, perhaps surprisingly, is that actually almost all of the cases the Supreme Court decides these days are cases that the justices have specifically chosen to hear, and not just cases that were foisted upon them. At CS Westbrook asks, do you know approximately how many cases the Supreme Court takes every year? The Supreme Court receives somewhere between 4,500 and 6,000 requests every year to hear appeals, whether from the lower federal courts or from the state courts. It only takes about 65 or 70 of them. What that means is that in 98 to 99% of those cases, it's actually those lower courts that get the last word, and the justices leave those lower court decisions intact. So the process the Supreme Court follows for picking and choosing cases is very secretive, but basically the parties file briefs where the party that wants the Supreme Court to hear the case says, here's why you should take it. The party that won below says, no, here's why you shouldn't take it. And the justices and their clerks debate internally what to do, and they ultimately vote. Should we hear this case or not? At Ken Hicken asks, yes or no, can the Supreme Court be expanded? Yes, the Constitution does not provide any limit on the size of the Supreme Court. It gives that power to Congress. Congress used that power a number of times between 1789 and 1869 to change the size of the Supreme Court. It's really a question about politics, whether it's a good idea and whether there are the votes. And at least since 1869, the answer to one, if not both of those questions has consistently been no. An anonymous Reddit user asks, what's the purpose of dissenting opinions? Sometimes a justice will write a dissenting opinion to make clear to their colleagues just how wrong they think the majority is. Indeed, we have examples of a proposed dissenting opinion actually persuading enough justices that it's correct that it became the majority opinion. Sometimes the goal of the dissenting opinion is to lay down a marker so that even if the Supreme Court's not going to reach the right answer, maybe other actors can. A famous example of this is when Justice Ruth Bader Ginsberg wrote a dissent in a case called Ledbetter about pay equity that called on Congress to fix the relevant federal statutes with regard to pay equity in the workplace. Congress did, and it actually passed a statute called the Lilly Ledbetter Fair Pay Act in response to Justice Ginsburg's dissenting opinion. And sometimes dissents really are meant more for the public, where the dissenting justice understands that they don't have enough votes for their position on the court, but they're writing for posterity. They think that one day the law will catch up with them. And some of the great examples of this are from Justice John Marshall Harlan, who dissented in cases like Plessy versus Ferguson, which established the principle of separate but equal in a way that actually we now rely upon, that has largely become the law of the land. At Real Miss Kim asks, which Supreme Court justice retires next and who replaces him or her? So if history has taught us anything, it's that it's not always who you'd expect. I think for obvious reasons, most of the attention right now is on Justices Clarence Thomas and Samuel Alito, since they are 2 of the 3 longest serving Republican appointed justices on the court, and the ones who I think would be most willing to have President Trump pick their successors. But Justice Thomas is also just a couple years away from the all-time longevity record for Supreme Court justices, something I suspect he's interested in. If you really forced me to bet, I would say Justice Alito is probably at the top of the list for the next justice to retire, but I'm glad I don't have to put any real money on it. Weary Farmer 4894 asks, did RBG destroy her legacy by not retiring during Obama's presidency? This is a real debate, not just about Justice Ruth Bader Ginsburg, but about what a Supreme Court justice's central obligations are. Famously, Justice Ginsburg did not retire when President Obama was in office and Democrats controlled the Senate. And that meant that when she passed away after a long battle with cancer in September 2020, it was President Trump who was able to fill her seat, as he did with Justice Amy Coney Barrett. I think it's really tricky to think about this question because retiring solely for partisan political purposes, even if it's something the justices do, is maybe not in the best long-term interest of the institution. If we view the court through the lens of just who controls which seats, then we really are accepting the premise that the court is a partisan institution and not just a judicial one. At the same time, justices who care about their legacies have to care, especially in this day and age, about those partisan politics. Only a justice knows their body, only a justice knows their mind, but I think it certainly looks in retrospect like it probably would have been better for Justice Ginsburg, if she cared about such things, to step down when President Obama could have chosen her successor instead of President Trump. At Po'boy Reeves asks, how ugly was the Kavanaugh confirmation? It was pretty ugly. There were seemingly quite plausible charges of sexual misconduct on the part of a much, much younger Brett Kavanaugh. You had a rushed FBI report, and you had, I think, a fair amount of railroading on both sides to the fight over who would replace Justice Anthony Kennedy. And I think we have to remember that part of what was going on there was you had the justice who had become the median vote on the court. It was his seat that was at issue, and I think that's part of why you saw the emotions get so high. How do we fix that? Well, I think this is a larger and deeper conversation about our institutions and about pushing presidents, pushing senators, pushing everybody to a point where we view the courts in general, and the Supreme Court in particular, as a critically important check on the other branches of government, a check where we're going to want judges and justices, not just who believe things we agree with, but who are going to assert the power of the courts over the other branches of government. That, to me, is the real unfortunate consequence of the Kavanaugh confirmation, is that if anything, it's moved us more into our political corners and not more toward that kind of institutional understanding. At They Love Sierra, how did Plessy versus Ferguson change law and society? So Plessy versus Ferguson is the infamous 1896 decision in which the Supreme Court articulated the separate but equal understanding for racial discrimination in public places. You can draw a straight line from Plessy versus Ferguson to the era of Jim Crow, to the idea that you would have segregated drinking facilities, segregated schools, segregated bathrooms in cities and jurisdictions, especially throughout the South. I think there's a debate about just how much Plessy itself caused those changes, or how much Plessy at least meant the courts had no way to stop those changes, which in many respects were already well underway. Indeed, it wouldn't be until Brown versus Board of Education in 1954 and the civil rights movement that Brown was an early part of that you really see efforts to push back against, to dismantle Jim Crow. The Supreme Court's obviously part of that story. It's probably a little much to say that the court was solely responsible for it. At Stevo2385 asks, when did the left ever have control of SCOTUS? Seriously, when was the last time there was a liberal majority? So I think there's actually some debate about this, because until 2010, you had a long history of Supreme Court appointments that were not necessarily party and ideology aligned. For example, Justice William Brennan, who for a long time was the liberal lion of the Warren Court, was appointed by a Republican president, by Dwight Eisenhower. The last time that a majority of the Supreme Court included justices appointed by Democratic presidents, which might be one way to think about this question, was May 14th, 1969. That was the day on which Justice Abe Fortas resigned from the court. Actually, Republican presidents would have the next 11 appointments to the Supreme Court, which is a big part of why there was such this profound shift in the court's jurisprudence starting in 1970. Reddit user asks, at the time of Roe v. Wade, was the Supreme Court overwhelmingly liberal? Not necessarily. I mean, the Supreme Court in 1973, when Roe v. Wade was decided, was in some respects a court in transition. And so you had a 7-2 majority in that case, but there were multiple justices in the majority who had been appointed by Republican presidents. And one of the two dissenters, Justice Byron White, was actually a Democratic appointee. He was appointed by President John F. Kennedy. At the time Roe v. Wade was decided, the question of the constitutionality of protections for abortion just didn't quite divide us so strictly into ideological camps as it came to in the years and decades to follow. At Core Flautus asks, how did Citizens United affect elections? So the Supreme Court's decision in Citizens United is actually part of a larger series of decisions in which the Supreme Court has interpreted the First Amendment to prohibit a number of restrictions on campaign finance and to prohibit a number of campaign finance reform initiatives enacted by Congress. The result has been a much larger amount of dark money in our elections, local elections, state elections, federal elections. The real impact here is not that it's obviously pro-Republican or pro-Democratic, it's pro-money. Moneyed interests have had much more say in our elections in the last 15 or 20 years, certainly than was true for a long time before that. At JSC 1835 asks, Trump is asking the Supreme Court to partly allow birthright citizenship restrictions. Will the Supreme Court allow this breach of the Constitution? This is getting a bit into the weeds, but one of the things that's really tricky about the 3 birthright citizenship cases that the Supreme Court is deciding during its current term is that the court is being asked not to uphold the policy, but rather just to let it go into effect as applied to at least some people through a procedural debate. Basically, the argument is the lower courts ruled too broadly in blocking President Trump's efforts to limit birthright citizenship. I suspect that the court is going to narrow those lower court rulings in at least some way, but also that either the Supreme Court or the lower courts pretty quickly are going to reach the end of this case and rule conclusively that the president's efforts to limit birthright citizenship are in fact unlawful, which will mitigate the effect of a procedural ruling that makes those lower court decisions less effective. At Juliet FES asks, in the country's history, has a Supreme Court justice ever resigned? So a number have resigned. Perhaps the most notorious resignation was in 1969 when Justice Abe Fortas resigned because of alleged improprieties with a financier named Lewis Wolfson. But there actually have been a number of justices who have resigned for other reasons, for health reasons, for personal reasons, in some cases because they wanted or were appointed to different jobs. It's really only in the last 10 or 15 years that we've seen high-profile deaths by sitting justices. We actually had gone a very long time, from 1954 to 2005. There wasn't a single justice who died on the bench. The norm had become resigned before the actuarial tables catch up with you. At the Drive-In 47 asks, what are the duties of the Chief Justice? So the Chief Justice is, in some respects, the first among equals. He doesn't have special extra powers that the other 8 justices lack. What makes him special is he is the senior justice. He basically presides over all of the court sessions. He gets to decide whenever he's in the majority who's going to write the decision for the court. And he is, in various respects, the ceremonial figurehead of the judicial branch as set out in Article 3 of the Constitution. But when the justices are in their conference room and they're voting on cases, the Chief Justice really is just one of 9. At Christo532-94495 asks, can you tell me in US history which president has appointed a justice representing the opposite of his beliefs? Perhaps the most famous of these is President Eisenhower appointing Justice William Brennan in 1956 as a Catholic Democratic state court judge from New Jersey, not because of his ideology, but perhaps despite it. But in general, I mean, really until the 1950s and 1960s, there are a lot of examples throughout American history of presidents prioritizing geographical diversity, other types of experience, of presidents cashing in political chips, or even in some cases of presidents using Supreme Court appointments to neutralize the folks they were, rivals with. It's really only in the last generation that we've come to think of Supreme Court appointments as being purely about maximizing ideology. A Reddit user asks, why did LBJ nominate Thurgood Marshall? Justice Marshall, when he was nominated to the court in 1967, was the first justice in the court's history who was not white. And this was a really important step by President Johnson. President Johnson thought it was long past time that the Supreme Court have a black justice. Indeed, he actually manipulates the circumstances just to create a seat for Justice Marshall. He took Ramsey Clark, who was the son of a sitting Supreme Court Justice, Tom Clark, and he appointed Ramsey Clark as the Attorney General. That would have meant Tom Clark would have had to recuse from every case in which the federal government was a party. LBJ knew he wouldn't do that. LBJ knew that Tom Clark would resign from the court, thereby creating the seat for Thurgood Marshall. At Puny Citizen asks, how does the shadow docket work? The shadow docket is a term that was coined by a University of Chicago law professor, Will Bode, in 2015, and it was meant to describe everything that the Supreme Court does other than the 65 or so cases it decides after briefing an argument every year. So that includes all of the rulings where the Supreme Court declines to take up an appeal, and it includes this other chunk of decisions where the Supreme Court is asked to provide something called emergency relief. Emergency relief is when you have a case in the lower courts that has not gotten to the Supreme Court yet, but One party, presumably whoever lost below, wants to change the status quo while the case works its way to the Supreme Court. And that's become an increasingly prominent part of the Supreme Court's workload. It's why the shadow docket has become so much more, I think, a subject of popular interest, especially as we've seen during the second Trump administration. So many cases where the federal government is asking the Supreme Court to temporarily pause lower court rulings blocking various policies while those cases work their way through the courts. A Reddit user asked, what was the first Second Amendment Supreme Court case? Really, the first time the Supreme Court discussed the Second Amendment in detail was in the 1930s in a case called Miller, where the court basically said that the Second Amendment didn't protect an individual right to self-defense. It was mostly a collective right to resist tyrannical government. Of course, it was that understanding that the Supreme Court overruled in 2008. Since the Supreme Court's decision in its 5-4 decision in Heller, what we've seen is a lot more litigation challenging and succeeding in striking down limits on gun sales, gun possession across the country. Yuki Kola asks, what do the US Supreme Court justices actually do during a regular workday? Most of the justices' work goes on in their chambers. In the Supreme Court's official headquarters in Washington, a building, by the way, the court has only had since 1935, the justices each have their own chambers, they have their own staffs, they have 4 law clerks who are recent law school graduates, and of course they have administrative support as well. And most of what they're doing is reviewing cases, either which cases they're going to choose to hear or not, or in the subset of cases the justices have chosen to hear, reading the briefs, preparing for argument, writing opinions, reviewing other justices' opinions. The justices really only gather in person formally when they're on the bench, hearing arguments or handing down decisions, or when they are back in what's called their conference, where they decide how they're going to rule on specific cases. Blank to hide from wife, can the US Supreme Court in practice make law? This has been really a bit of a metaphysical debate among scholars for a very long time. Everyone agrees that judges, and the Supreme Court in particular, have a responsibility to interpret the law. The difference between that and what we might call making law is often elusive, and actually there are contexts in which we expect judges to do more than just resolve ambiguity, perhaps to fill in language that Congress or the state legislature has left out. So yes, I mean, I think there are lots of contexts in which the judges and justices are and should be allowed to make law. We just tend to think of those in the context of interpreting statutes, constitutional provisions, and other legal texts. Haggisman asks, ideally, should the Supreme Court lean toward originalism or living constitutionalism? This is an age-old debate about how judges and justices should interpret the text of the Constitution when that text is ambiguous. No one really disputes that when the Constitution says the president has to be 35 years old, it means 35. But when the 8th Amendment says something like, there can be no such thing as cruel and unusual punishment, that of course raises questions. What makes a particular punishment cruel and unusual? Throughout the court's history, one of the ways we've addressed this issue is by having justices who were diverse, who were from different parts of the country, who were from different backgrounds, who had different methodological commitments. And it's really only in the last generation that there has been this concerted push toward the idea that there really can only be one accepted way to interpret the Constitution. I'll just say that I think the better answer is different people are going to have different commitments based upon their own views, their own experiences, their own background. And part of why we have 9 Supreme Court justices and not just 1, part of why we have humans interpreting these texts and not machines, is because those differences, that diversity, is actually a really important part of the project of legal interpretation. At DJ vs. Everybody asks, how do states' rights fit into having the Supreme Court have the ability to overrule state courts? The Constitution divides sovereignty between the federal government and the states. One of the ways it does so is it leaves questions of state law up to state Supreme Court. So if the Missouri Supreme Court interprets Missouri law in a particular way, the Supreme Court has no power to disagree with them. The difference is when it's about federal law. And so if a state court interprets a federal statute or the federal Constitution, or if a state court interprets state law in a way that is inconsistent with federal law or the federal Constitution. That's where the US Supreme Court is able to come in and is able to reverse that decision. Amrek asks, how does the Supreme Court go about overturning a previous ruling? It's actually not that complicated procedurally, it's just fraught in the sense that it tends to be controversial when the Supreme Court overturns a prior decision. There's nothing that actually prevents any justices in any case from saying, hey, we actually think this prior decision is wrong and should be overruled. You need a majority, of course, and presumably you need some compelling reason why that older decision should be overruled. The principle of stare decisis is the idea that all things being equal, courts should follow the decisions of their predecessors. If and when there are especially persuasive reasons to overrule a prior precedent, that's when the court is, I think, more free to do so. Quartix asks, why does the US Supreme Court rely on precedential cases? This isn't just the US Supreme Court, this is actually a feature of any so-called common law legal system. And the idea is that precedent is itself part of our law, that what separates judges and justices from ordinary politicians is that they're not just voting their preferences in every individual case, that there is actually this abstract idea of what the law is that binds not just current judges, but future judges, until and unless there's some compelling reason to overrule it. That's not just a sort of principle of laziness, it's actually a really important foundation of what separates judicial power from ordinary political power. At Andrevin20, do I think the Supreme Court was always 9 seats? How did it get to 9? In fact, I know it wasn't. The Constitution itself says nothing about how big the Supreme Court ought to be. Congress, when it created the court in 1789, started with a very strange number, with 6. That was really based on how many lower appeals courts there were. Between 1789 and 1869, the size of the court fluctuates 7 times, between as many as 10 justices for a brief period in the 1860s, and at one point as few as 5 justices. It's only in April of 1869 that Congress for the first time hardwires the number 9 into the identity of the Supreme Court, and we've been set at 9 ever since. There have been proposals at various points in the recent past, especially during the Biden administration, to pack the court by adding perhaps 4 seats. Practically, you're never going to be able to do it unless the same party simultaneously controls not just the White House, but both chambers of Congress and has a filibuster-proof majority in the Senate. And in the long term, I mean, if you're expanding the court solely to maximize short-term partisan political advantage, I think that probably redounds to the detriment of the integrity of the court, of public faith in the court, even if part of why folks are proposing that as a reform is because they think that damage has already happened. I'm not sure this is an example of 2 wrongs making a right. At My Opinion 6810 asks, how do Supreme Court justices get impeached? Has that ever happened? So it's the exact same process in the Constitution for impeaching a Supreme Court justice as it is for the president. It takes a majority of the House of Representatives to impeach, 2/3 of the Senate to vote to convict and thereby remove. It's happened exactly once with a Supreme Court justice. In 1804, the sort of Jeffersonian-controlled Congress impeached and tried to remove Justice Samuel Chase, who has perhaps the greatest nickname in Supreme Court history. He was known as Old Bacon Face. And Justice Chase was impeached because the Jeffersonians thought that he was basically a partisan hack. But the Senate refused to remove Justice Chase. It wasn't that they decided that he was not a partisan. It was that they decided that wasn't enough, and that to remove a Supreme Court justice, you need actual misconduct. And that's really stood as a pretty important precedent for judicial independence ever since. Oddflower 2744. What actually happens if Supreme Court decisions are just ignored? What mechanisms actually enforce a Supreme Court decision? It depends on who's doing the ignoring. Of course, if it's private parties, there are lots of ways to compel their obedience to Supreme Court decisions, whether it's monetary sanctions or otherwise. It is, of course, trickier if the relevant party is the federal government. Historically, the way the Supreme Court has been able to effectuate its mandates is because the political consequences of a president defying the Supreme Court have just been too high. President Nixon turned over the Watergate tapes, including the tape that led directly to his resignation, because he concluded with the support of his advisors that he couldn't defy the Supreme Court. President Eisenhower sent the army into Little Rock in 1957 to desegregate Central High School because he was persuaded that he couldn't not enforce the Supreme Court's decision in Brown versus Board of Education. That's why the Supreme Court's legitimacy, why public faith in the court is so important, because if we get to a point where a president could stick his thumb in the Supreme Court's eye and have no similar political backlash, that would be the point where the Supreme Court's power as an institution would be critically and perhaps irrevocably damaged. At Ajebo Lawyer asks, do I know the difference between the Supreme Court of a state of the United States and the Supreme Court of the United States? In fact, I do. So every state has a Supreme Court. Actually, Texas and Oklahoma have two, one each for criminal cases and for civil cases. But those courts are principally tasked with interpreting state law. Sometimes you can have federal issues come up in those cases. A state criminal prosecution, for example, can raise Fourth Amendment issues. But typically, the state Supreme Courts get the last word on the meaning of their state's laws, and the US Supreme Court gets the last word on the meaning of federal law. A Reddit user asked, what government entity has oversight over the US Supreme Court that's now showing almost open corruption, from payments for housing, vacations, and payment of schooling for children? So this has always been a little tricky. I mean, the Supreme Court is an independent branch. It is not supposed to be subject to oversight in quite the same ways that maybe lower courts might be, or the executive branch agencies. Historically, the way this has worked is there has been a healthy, but sometimes heated, back and forth between the political branches and the Supreme Court. Congress controls the Supreme Court's budget. Congress controls the Supreme Court's docket. And those have been levers that historically Congress has pulled as a way of pushing the justices to behave better. One of the things that has really happened in the last 25 or 30 years that has gotten us to where we are today with the Supreme Court is Congress has mostly stopped pulling those levers. And so when we talk about problems with the current Supreme Court, when we talk about opportunities for reform of the current Supreme Court, I like to start with the accountability question. How can Congress impose more accountability on the justices without interfering with judicial independence? Maybe part of that starts with an inspector general within the judicial branch, someone who could supervise whether the justices are complying with the relevant ethics and financial disclosure rules. Maybe it starts with getting back into the norm of having the justices testify before Congress, something that used to happen with somewhat more regularity. Whatever you think the specific answer is, though, I think a big part of how we've gotten to where we are today with the Supreme Court is we have a court that is not and does not think it ought to be accountable to the other branches the way that was true for most of American history. Well, I think that's it. I've tried to answer all your questions. Hope you've liked the answers. Thanks for joining us. Until next time.